All right, guys, we are now live for another monthly episode of Alabama Work Comp Today. We try to come to YouTube for about an hour, give or take, every fourth Thursday of the month. So that's where we are today. And as we do, we bring on a friend, a colleague who practices similar work that we do from different parts of the country. And we talk about the news topics, the articles, the what's interesting, what's newsworthy from the previous month that deal with employers, employees, and independent contractors. Now, admittedly, it's been very COVID heavy the last 4 or 5 months. I think we may break that trend a little bit, but I want to welcome from Atlanta area, Chinny Law with Ramos Law Firms. Welcome, Chinny. Thank you for having some time for us today.
Thank you. Thank you for having me today.
Most welcome. Well, I have briefly known Jenny. David's known her for longer through the organization that we all three belong to, WILG. So, Dave, I'm going to turn it over to you for a minute before we turn it back over to Jenny.
Yeah, sure. Thanks. And so glad Chinny Law has joined us today. She is a work comp lawyer in Atlanta at the Ramos Law Firm. And with the last name Law, she had to, of course, become a lawyer. And we're so glad that you are a work comp lawyer and do the same type of work we do and help injured workers across the state lines in Georgia. And as Bernard mentioned, we've gotten to know Chinny through the Workers Injury Law and Advocacy group, and which Chinny is a member of. So Chinny, so glad that you are our guest lawyer today. Look forward to talking with you. And if you'll tell our audience a little bit more about you.
Sure. Thank you, David. So yes, my name is Chinny Law. I am born and raised here in Georgia. I'm a Georgia peach. I exclusively practice workers' compensation here in the city of Buckhead. And we only handle workers' comp claims here at the firm. Workers' comp is pretty challenging here in Georgia, and there are not a lot of benefits available to our clients. And so we try to do one thing here, and we're still trying to learn how to do it well, but we certainly do our best.
Well, we appreciate you having time for us, and we're really looking forward to diving into some of these topics. And as we said in the past, we have been so concentrated on COVID related issues. We're not going to completely get away from that, but life is settling down a little bit. People are finding their footing in society. They're finding their footing in their law practice. I know that we have made changes. I'm sure you guys have as well, Chinny. And let's just get into it. Our first article today, guys, comes out of Colorado, and it's a tragic story. But it says after meat workers die of COVID-19, families fight for compensation. And it's, to me, at least in part, this article, what it's talking about is just another, yet another example of how people are having to fight for rights when it deals with COVID issues. David or Chinny, either of you guys, what did you see here? What was disturbing? What was helpful? It doesn't matter, either of you guys. Go ahead and let's just talk about it.
Chinny, I just want you to start us off.
Sure, thank you. I was going to say this article reminded me a lot of clients that I have that work in the chicken plants here in South Georgia. And this article was just a very real description of what clients go through, but not just what our clients go through, but what their families are dealing with as well. I noticed here in Colorado, there was a discussion about how the legislature was in the process of trying to find legislation that would make workers' compensation benefits available to these injured workers in Colorado. And I will say it made me think of Georgia because Colorado is several steps ahead of us. So here in Georgia, we're not even in the process of creating legislation that would provide workers' comp benefits for injured workers here in the state. I do know that there are some concerted efforts that are pulling together resources that hopefully we can bring this to the attention of the legislature here in 2021. But that's Colorado is a step ahead. That's not to minimize the injury or the stress and the difficulty that this family is going through, but it's really sad. It's heartbreaking, and it really brings to light how much this pandemic has affected the workforce across the nation.
I noticed in here, David, it says at least one of 6 employees at the plant to die from COVID-19 back in April.
Yeah, that's something I wanted to focus on, was the numbers. And Chinny, you did a real good job explaining, and I'm going to focus a little bit on the numbers in this article because the numbers jumped out at me. The article features Mr. Sanchez, who passed away at age 78. He was one of 291 people who tested positive for coronavirus at the JBS plant in Greeley. 44,000 meatpacking workers have tested positive for coronavirus, and more than 200 have died. JBS is the employer that's featured in this story from the New York Times. JBS is the world's largest meat processor. They reported more than $36 billion in net revenue in 2019, and they have about 6,000 people working at their plant in Greeley. So just wanted to point out some of the numbers, because those are some big numbers. And one other thing I'll point out before turning it back over to you guys is that our friend Mac Babcock out of Colorado, and a former guest on Alabama Work Comp Today, represents some of the employees and their families from this plant. Mac is interviewed and gave a statement as it relates to this interview or this story. And as Mac said, this is a game of attrition where they're using these workers as just replaceable parts. And as Mac says, I think it's immoral. And I agree with him.
How can it be anything other than that? You're placing profits over people.
Yeah.
And unfortunately, that's whether it's COVID or some other issue that addresses large number of employees who work in particular plants. We see it in all over the place. Could be chemical spills. It could be other environmental issues where they're exposed. And anyway, it just is so frustrating. I know it's the kind of work that we do, and Chinny, I know you do this work as well. But one of the hardest things that we find is when we have to tell people who contact our firm, well, here's what the law does do, but here's what the law can't do, and I can't help you. The only thing we can do is hope that the laws change into the future. And that's what breaks my heart all the time when we deal with these kind of situations.
Yeah. The article mentions where Mr. Sanchez's daughter says, we just have a stack of medical bills, and they're just, we're just waiting to see how we can address them, because right now our hands are tied and our financial resources are limited.
I don't know if this is a fair comparison, but all of the problems that those who were injured or killed or developed serious medical problems after 9/11, all of the first responders, were now 20 years later, and they're still fighting that fight. They're still dealing with those issues. Now, as it turns out, the COVID exposure numbers may be much greater, but I think the argument is still very much the same argument. But I don't know if they have found peace or much resolution to that situation dealing with 9/11 and first responders. But anyway, that's each of these articles David and I have found could be on their own each month. We could speak for just an hour with our colleagues just about one article. We certainly could with this one, but we've got other articles and other things to talk about, so we need to keep pushing forward. This next article is going to take us to the state of Washington and an employer who has been mentioned on our show, oh gosh, half a dozen times or more, one of the largest employers in the country, and that's Amazon. And the title is Amazon's warehouses have more costly workplace injury claims than meatpacking or logging, according to Washington State. And Chinny, are there any Amazon plants in the state of Georgia? Are you aware?
There are. We have a fulfillment center here in Lithia Springs. It's not too far, about an hour away from the city.
And David, we've just recently added, or they're going to be adding one in Bessemer, isn't it?
That's right. That's right.
So it wouldn't surprise me if every state ultimately has its own. Like our brother near Richmond, Virginia, I'm sure they have multiple plants there or locations, but they also have one of those services where if you order it, you can have it received to your home within like an hour or two. I don't know what they call that location, but it's awfully close to where he lives. So I'm sure Amazon locations are just about anywhere these days.
I thought this really jumped out at me, that Amazon has at least 24 logistics facilities in the state of Washington alone. 24 in one state, and that covers nearly 7 million square feet. It's just amazing. And what I didn't have time to do was look up to see like how many square feet are, say, in Rhode Island or just in the state of Washington, just for comparison, because that's incredible.
I noticed that too, David. I was like, 7 million.
Could you imagine the power bills for that?
Yeah.
Oh my gosh. Well, Chinny, let's go to that article. And I don't know if it's just the sheer volume of the number of workers compared to the meatpacking and logging industries now, or if it's per capita, but this is just kind of eye-opening to me about what's going on within the world of Amazon and its employees.
Sure. And there was a statistic that stood out to me in this particular article where it said that, across 150 fulfillment centers nationwide, there was a 33% increase of injuries between 2016 and 2019. So, I do think the larger the plant is, or the larger the warehouse is, by default, they're probably going to have higher numbers than say a smaller warehouse. But just in general, I think there's been this highlight of Amazon and its workers in the fulfillment centers because the numbers seem like they just continue to increase. And in our environment where we are all relying on Amazon, I watched your last episode where you guys had mentioned relying on Amazon a lot for groceries and supplies. I think the use of Amazon will continue to increase, and they're going to continue to hire more employees. So it's problematic, and I don't know the solution. I'm not sure if this particular article is talking about increasing, their workers' comp premiums but I would like to look more into why are these injuries really happening and what is causing the increase in these injuries, as far as, is it a safety issue? Is it a pressure to perform and a pressure to meet quota and data? What is it about the structure of these fulfillment centers that is causing the increase in the injuries?
Well, it's David, if you remember, I don't remember if it was last month or which month it was, we talked about with humans interacting with more and more of Amazon's machines, and the humans either not being as trained or as used to the flow of what goes on within the dynamics of the warehouse, or the machines aren't calibrated properly, or all of the above, because it's so new. That, at least that article that we talked about a few months ago, are all contributing factors. And Chinny, I think everything that you mentioned, every bit of this is contributing factors, because it's all such a newly evolving industry. It really is. And it's, Dave, I don't know if you took anything new out of this article other than shaking your head like, well, no, I'm not really surprised that this is going on.
No, it's fascinating when you think about, the most dangerous jobs in terms of in relation to work comp premiums. You're talking about logging, you're talking about law enforcement, They mentioned meat packing plants, like we just discussed. Those are the most dangerous jobs. And as a result, the work comp premium that those employers pay is among the highest, right? Whereas the premiums we pay as office workers or for our assistants who are in the office is much lower than that of a logging company or a meat packing company. And what this article, it just fascinates me that they're saying that working in these warehouses is more dangerous than those jobs, than a logger, a meat packer, working in law enforcement. And that doesn't seem it should be that way, that working in a warehouse is more dangerous, or working in a fulfillment center is more dangerous than those jobs. But so as a result, Amazon needs to take a hard look at that. And yeah, you're the biggest employer in the country, close to in the world. You got to have a bullseye on your back, and they need to do a better job of keeping their workers safe.
Well, think about this, Chinny, David. Our society obviously is changing each day, each week, each month. And with the pandemic that we've been in now for 7-8 months, that sped up and or changed a lot of how society operates. Case in point is the food delivery and grocery delivery services that have been out there, but not nearly the percentages before the pandemic as now, because the number of employees or workers, I don't know if they're classified necessarily as employees, and I know that some of our colleagues hate the term gig economy. They use other terms for it. But if you really think about, at least I can share with my experience, I have used food delivery services, and the grocery, like Shipped, is based out of Birmingham. It started here, 3 miles from my house. I've used that so often, and it's just part of the evolving society and what is now becoming the norms. I think that's what's happening with Amazon. I'm sure that their numbers have exploded in terms of usage and profits and number of people they've been hiring. And it just shows our society's changing from those types of things within.
And even when we're past this pandemic, I think a lot of these things that are normal now are going to stay in place.
Oh, sure.
Too reliant on them.
I don't want to speak for you, Chinny, but I can assure you that David and I share the same passion for not wanting to go into the grocery store with a list to have to pick up items. I'd much rather pay somebody to deliver them to my door anytime, any day.
Absolutely. We've done the same here. Instacart, Amazon, whatever we can do to limit exposure of walking into a big store, we're doing the same here. Yeah. So it's interesting, this Amazon article, because I agree. I think they're just trying to keep up to and adjust to the times. But, I also think when you're a large employer and a situation like this has benefited your business, you have a responsibility to take care of your workers and ensure that while your business is growing and while you're opening more fulfillment centers and hiring more employees, that you're doing it in a way where everyone is safe and where the injury rates are low, hopefully.
Well, and guys, I want to pause for just a minute and welcome again anybody who's watching us live. You're certainly welcome to post comments on what we're chatting about, or if you have questions for us, throw them in the comments. I'll see them and I'll field them to David and to Chinny. We want to welcome again Chinny Law with the Ramos Law Firm in Atlanta. Chinny's a fellow WILG member and similar practitioner in the state of Georgia, and just does such a fine job for her clients in the world of work comp. And that's why we've invited her to come on today to talk about issues that this is what we deal with every day. And it doesn't matter what state we're in, there's so much similarity. And guys, that's what's going to take us to our next two articles, one out of, again, the state of Washington and the other one out of the state of Florida. And unfortunately, they both involve fraud. And the first one is Florida construction owner accused of not paying $95,000 in work comp premiums, which that's a real problem. And then the other out of the state of Washington, ex-police chief, an employee in Washington, turned pinup model charged with workers' comp fraud. And I don't want to make light of the second article, but holy smokes, we got to start with that one. And I'm gonna leave that David, you take the lead on that one.
It's a great headline. I'm going to start off with the headline again. Ex-police chief in the state of Washington turned pinup model charged with workers' comp fraud. So there's a lot going on in this one. This is a woman who faced 2 charges of making false or misleading statements to collect more than $60,000 in work comp benefits from the state of Washington. She was a police chief of a small town when a corpse fell on her during a police call. A domestic violence suspect had hanged herself in a barn, and she tried to take down the body, and the 280-pound corpse fell on her. That's where her problems began, but they only got worse because she made them worse for herself. So she went through several years of medical treatment, including 4 years of receiving mental health treatment without any improvement. Well, this caught the attention of the workers' compensation carrier, and they did some investigating on her. And here's where the pinup model comes into play. So she was, for more than 5 years, was being photographed as a pinup model, organizing pinup pageants and fundraisers. She was dressing up as, in the style of actress Betty Grable and Rita Hayworth during World War II. So in other words, she's out receiving work comp benefits, but she's also receiving money on the side. And when you're off work getting what's called temporary total disability benefits, you cannot receive wages in another way. That is illegal. That is a violation of most every state's laws, whether it's Alabama, Georgia, or the state of Washington. And so she got herself in some trouble. It was pretty easy for her to get busted because she's putting most of this on social media. Mm-hmm. So that's my summary.
This is just crazy. This is just straight up a crime. And Chinny, I don't think the average person, I know we've all dealt with these clients who have come to us with questions. Hey, can I do X while I'm off of my job because of my injuries and I'm getting paid comp? And I know that our answer is, well, are you going to be paid for what you're going to be doing? And then you have to go down that trail of questions. So I don't think it fully resonates with the typical, and I'm not saying that they're dumb. I'm not saying that at all. I'm not trying to be derogatory. But when you say crime, I don't think that resonates with them until we explain to them why and how they can get in some serious trouble. Have you dealt with that, Chinny, in your practice?
I have. This article just, I have so many thoughts that come to mind, with this article, but I'll address your question first. And that is, my clients sometimes don't understand really what the system is and what are the ramifications if they collect income benefits in a situation where they probably shouldn't. So a lot of times I have to say, the reason why you're collecting income benefits is because the doctor has placed you out of work. So the whole premise that you shouldn't be working or can't work because you're recovering from your injury is really what entitles you to receive these income benefits. So anything that you do to jeopardize that is very problematic. And you better believe the insurance company eventually will account for that and try to recoup those benefits. And so, yeah, it's a serious issue, and it's very difficult once those income benefits have been issued for the insurance company to collect that, and it becomes a real pickle that you have to help your clients with. My other thought behind this, though, is, it really, and this may not have been the case in this particular police chief situation, but I have many clients who say, Chinny, I can't survive on my weekly check, and I've got to find a way to survive. And is it okay if I do X, Y, and Z? And then you have, those difficult conversations about what you think may be acceptable and what may not be, and what may jeopardize eventually their ability to collect income benefits. in this particular case, I'm not sure the activities were done out of financial necessity. I can't speak to that. I really have a lot of questions about this article and the situation here. But I will say, in my experience with my clients, a lot of times when they're asking, can I do something else? It's because they're really just trying to find a way to survive, to supplement the weekly workers' comp benefits that they're getting, because it's just not anywhere near what they were originally getting. Go ahead, Bernard.
Let me throw a scenario to you guys just for this discussion. What if you have a person who has two jobs, and one job they work 40 hours a week, the other job they work 20 hours a week, they get hurt on the main, what I'll call the main job, working 40 hours a week. And the doctor takes them off of that job. And the new client comes to you and says, A, am I going to get weekly checks? And B, can I keep working my other job? Dave, what do you say to your new client about this?
Well, if they're taken off of work by the work comp doctor, then they're going to receive what's called temporary total disability benefits, which in Alabama will pay them 2/3 of their average weekly wage, which is 2/3 of the average weekly wage of the employer that they were working for when they got hurt. Mm-hmm. You cannot factor in the other employer, the second employer, and they cannot get lost wages in Alabama. They are just not allowed to earn or work that second job because they've been taken off of work by the doctor.
Okay, and before we get to you, Chinny, but now let's say I'm that new client, but I'm going to lose my other job. If I get these work comp benefits and I can't work that second job, they're going to let me go. How do I balance that? Now, I will say this, we've dealt with this, I'm sure you have too, Chinny. There's no easy answer here. I think it depends on a lot of factors like the severity of the injury and things like that. But Jenny, what if somebody comes to you with this scenario? How are you advising your new client about those things?
Sure. It's a tough discussion. Now, in Georgia, we have something called similar and concurrent employment. So if you have main job number one, and then you have job number two, you're injured at job number one, and you can't do job number two, like you said. If both of them are similar in nature, you are allowed to factor the wages for both jobs. And so the most common situation that we have is usually
not in our state.
So the most common situation that I have is I have a nurse who works 3-4 days a week at a hospital, and then she will pick up shifts in the evening for 2 or 3 hours at a time at a different hospital or at a different clinic. And in that case, if you can prove or demonstrate that the employment is similar in both jobs, you can account for both wages, and then that eventually is what will determine their weekly income benefits. Now, if their employment is not similar, and I have a lot of clients who have more than one job, but they're not similar in nature, it's a tough discussion. And I usually have to tell them, one, we have to consider the severity of your injury. If we're talking about an ankle sprain, then you may have to seriously consider whether or not you want to pursue this claim through job number one, and whether or not you want to how you're going to approach job number two. We also talk about, what is the earning capacity at job number one and job number two. And, if you don't come to work at job number two and they're going to fire you, like your example, what will that mean? So it's a difficult discussion. And a lot of times it'll just depend on the particular facts of both those employment opportunities. And I try to help my client, find the best answer. But more often than not, sometimes they have to forego pursuing a comp claim. And I hate that they have to do that. But I have to say, there are limitations in the comp system, especially here in Georgia. We can talk about different scenarios, and hopefully I can help you figure out what would be the best one out of this difficult situation. So the best option of all the worst options is really what I try to help them figure out.
The other thing that it also leads to is the conversation about surveillance. and how that fits into this equation and why you should always adhere to your current authorized treating physicians restrictions and limitations, because the last thing you want to see is a back injured client who has all of these severe limitations and there's surveillance of them doing roofing work or climbing ladders or whatever it may be. And it just cuts to what I consider the most important, the most crucial part of a work comp claim. And what is that, David?
The credibility of the injured worker, Bernard.
Bingo.
Yeah, they got to be honest. If they can't be honest, then we probably can't help them.
We all have those stories where on cross-examination in a deposition, or hopefully not ever at a trial, where videos come out or photographs come out of something that is completely contrary to what the claim really is about.
Yeah.
Anyway,
when the employer and work comp don't have any defenses, what do? They cut to the final defense, which is the credibility of the injured worker.
Yep.
That's the last one.
Now, let's take it away from the employee situation to now let's go to this last article out of Florida. Florida construction owner accused of not paying almost $100,000 in work comp premiums and all of the fallout that has occurred from there. And gosh, when I'm reading this article, I'm cringing for these injured folks and all of the problems that the employer has created. Chinny, what did you get from this article?
Truthfully, I read this and I was just, disgusted. In Georgia, it's the law. You have to have workers' comp coverage if you have 3 or more employees. If you're a business, you're operating a business, you have employees, it's your responsibility to take care of them. And, it's the law, but it's also the right thing to do. And when you don't have coverage, it just creates this snowball effect where, like you said, it just creates an immense challenge for these employees to access benefits that they should otherwise be able to get quickly and easily. And it leaves the burden on them to have to pursue another way, to find access to medical treatment and income benefits. And it's just unfortunate because I think in the long run, $95,000 may potentially have been a small price to pay for this construction owner in terms of all the coverage he may have spent in terms of covering these workers' comp claims, not to mention the jail time he's now going to have to serve.
Yeah, I read in here, if convicted, he faces up to 25 years in prison. And individuals charged with the crime are presumed innocent until proven guilty. But holy smokes, how do you get away from, well, we didn't pay it? Where I don't know. David, did you glean anything additional from this other than disgust?
Yeah, I want to share the quote from Jimmy Peronis. He's the CFO of the Florida Department of Financial Services, which oversees their work comp program. And Jimmy Peronis says, businesses having the appropriate coverage for their employees is extremely important, and avoiding carrying adequate workers' compensation insurance is a crime, placing injured workers at risk and ultimately inflating insurance rates for honest businesses. Mm-hmm. And not only that, but if they don't have the insurance coverage, in Alabama, there's the double indemnity provision that the employer can be hit for 2 times the compensation if the employer doesn't have the insurance it should have. So I wonder if Florida has that as well.
I'm sure that Georgia and Florida probably have similar situated provisions. But Chinny, we can look pretty quickly on the Department of Insurance website for the state of Alabama for work comp coverage for particular dates. You just plug in the name of the company and the dates, and that really helps us to know where we're going with the claim. Additionally, we can look up in the computer database for the state filing and see if they've ever been sued and the like. But one of the things that is a real shame sometimes is when you have a company that skirts on that edge. We have to have 5 employees, and they skirt on that quarterly edge of having 4 employees this quarter, 5 this quarter, back to 4, back to 5. And I'm sure it creates a huge headache for the Department of Insurance to keep up with these things. But unfortunately, that's just the reality of a lot of these smaller businesses who that's one of the things that they cut out of their budget, so to speak, assuming they budget. I'm not going to cover coverage. I mean, cover you're even though you're doing logging work or roofing work for my company. You're on your own if you get hurt.
So I posted this a little while ago on our Twitter page at Alabama Work Comp. And it's the top 10 work comp fraud cases for 2018. Lynn Jernigan, a work comp lawyer in North Carolina, compiles this every year. He's at Jern Law, Jern Law. So in 2018, this is the top 10 work comp fraud cases. Non-employee fraud cases made up all 10 of the top 10 at $99.7 million in fraud.
Wow.
$99.7 million in work comp fraud for non-employee fraud cases. Employee fraud cases in 2018 were 0 as far as in the top 10. So what I'm saying is the fraud in work comp, the real money is coming from doctors, insurance companies, employers, self-insureds. That's where the real fraud, the real big money is coming in work comp fraud. Employees commit fraud, there's no doubt about it, but the real bucks, that's on the non-employee side.
Chinny, we have found that some of our biggest arguments in litigation is over because there's so much money involved with medical care now. That's where the big arguments come from most of the time. I don't know about your experience, but because we're litigation based in front of a circuit judge, and that's typically where we have to fight our fight. It's because the insurance companies want to either stop the bleeding, so to speak, after a long claim, and they just make an arbitrary decision to stop the case. I mean, stop paying for anything, and they force the employee into court, or they just look for any reason like notice to not even start the bleeding, so to speak. That's a terrible analogy, but they don't even want to start paying for it, which most of the time in an emergency situation, what are you going to do? You're going to go get your medical care and worry about who's paying for it after the fact. Right. You have no real choice. Do you guys see those types of fights?
Unfortunately, we see them every day. In fact, I have several cases, like you said, where they're pretty large cases. The injury is very severe, and the insurance company has been chomping at the bit since day one to find a way to close the case out and limit exposure. So much so that I normally have the majority of cases that I can think of now that are in the litigation posture is where the insurance company has denied medical treatment and then after the fact has gone on to build their case as far as why medical treatment should be denied. So I'll normally, let's say, for example, I've got a client who needs back surgery. The authorized treating physician has recommended back surgery for several months. Most of my cases, the insurance company will go ahead and deny the back surgery, and then they will go send them off for a second opinion months later, with an insurance doctor who'll say that the surgery isn't needed, and then claim that is the basis for the denial. And
Chinny, we could share some serious stories. We'll get David. How many affirmative defenses do we see on average in an answer to a lawsuit that just is the kitchen sink's worth of defenses? 99%,
25.
Yeah, 20 and Chinny, none of them have anything to do with the case. Statute of limitations, even though you filed it 3 days after the case happened. Just ridiculous stuff. But guys, for the last several minutes of our talk today, and Chinny, we sure have enjoyed having you on and sharing your perspective from Georgia and your experience. What we want to do now, we've covered the cases, the articles for this episode. We want to do a little comparison, and I think this is a good exercise that we like to take 3 or 4 areas of law that fit in both states and just do a little comparison. And unfortunately, it usually leaves David and me crying or whimpering a little bit compared to every other state that we talk with, but we'll plow through. We'll figure this out. And Dave, the first topic I want to talk about is the mediation process. So just give us like a 30-second overview about how mediation typically works in Alabama. And Chinny, I'll ask you to share with from Georgia.
Yeah. So for those that don't know what mediation is a voluntary process where the parties come together to try to settle their differences. And that's usually done with the help of a lawyer, or in Alabama, someone from the Department of Labor called an ombudsman. And the mediator is an impartial third party. They're not judging the merits of the case. They're just trying to help us resolve our differences. So a lot of our cases get settled at mediation, and we use both private lawyers and the ombudsman for that process.
Okay, Chinny?
Here in Georgia, we have a variety of mediation options. So an injured worker can request a mediation at the state board to have a hearing issue heard. We can also request a mediation that is to discuss settlement. Now, the state board offers mediations at no charge. The state board has a variety of mediators that you can request. And then our administrative law judges also will agree from time to time to help us mediate a case. And then more frequently, here we've been using private mediators. Those are usually retired judges or practitioners who have been in the field for a long time, who have earned the respect on both the claimants and the defense sides. And there's a variety of arrangements where, either the claimants pay half or the insurance company pays the other half. But here I've actually been requesting if the insurance company invites my client to participate in a settlement mediation, we've been asking them to pay for all of the mediation fees.
Just had that in one of my cases yesterday where they paid the full mediation costs. Dave, any other aspects of mediation that I think you may have covered it all?
No,
okay.
I think so.
Well, guys, let's move to another topic within our respective practices. We have an area sometimes where you can settle a case that results in what we'll call lifetime medical care. And that means different things in different states. In Alabama, Dave, what does that mean if you settle a case with open medicals or lifetime medicals? What does that mean?
Yeah. So when you're mediating your case, one of the things you can settle or that's at dispute at settlement time is whether you're going to leave your medical benefits open or close them. If you close them, then you get money for that, but you're on your own for medical care, and work comp's out of the picture. If you leave your medical benefits open, then that's a lifetime medical benefit, meaning work comp will pay for medical treatment related to the symptoms or injuries sustained in the on-the-job accident. And simple as that, it's a lifetime benefit. You have to see the authorized treating physician that's appointed by or designated by work comp. So you're talking over the course of lifetime, it could be, tens of thousands to hundreds of thousands of dollars, depending upon the ongoing need for medical care, whether there's prescription medications every 90 days, whether someone's paralyzed. You might see the medical bills in the high six figures to millions of dollars.
And before we get to you, Chinny, I want to follow up, Dave, with sometimes what happens in at least our experience is we encourage our clients that if they have that settlement situation to at least go to the doctor once a year, even if they don't have active symptoms, just to check in, just to make sure that there's a record kept. Because what happens, David, if it's 5 and 7 years down the road and they've had no medical care, but now their knee starts to hurt again that was subject to that claim, what typically happens then?
Yeah, at that point, you've got work comp questioning whether the need or the symptoms are even related to the on-the-job accident, because it's been so many years since they saw the work comp doctor. Plus, if they're not working for that same employer, but they're working for a different employer, well, work comp would say, well, how do we know that this problem with the knee is old. In other words, is it related to the injury from 5 years ago? So it's important for the employee to go see the doctor regularly, so there's not this huge gap in time. So it reduces the things work comp can question.
Chinny, I have a client right now who was hurt in May. Are you sitting down? 1986 with open medicals. And of course, now there's a new insurance carrier and a new adjuster on the file. So they've filed into court asking for a declaration from a judge who was in like third grade at the time this happened to make a decision whether or not the current medicals are still related to what happened in 1986. But anyway, go ahead. And how does Georgia treat lifetime medical in that situation?
Well, good luck with that, Bernard. I wish you the best on that one.
Thanks. Oh, and by the way, there's no provision for me to be paid for doing this work. And this was our dad's case. He's been retired 10 years. So sure, Dad, I'll take this on. No, we're going to get this worked out. But you see, it's kind of an extreme example here.
Yeah. Well, lifetime medical in Georgia really refers to the actual length of medical treatment, not necessarily in the context of settlement. So if your injury happened before 2013, an injured worker is entitled to lifetime medical treatment. So there's no cap on the length of medical treatment that they can receive. But similar to what you've said, we do encourage them to treat regularly and at least once a year, because the more time that goes on, the more problematic it's going to be if this injured worker wants to come back, umpteen years later and receive medical treatment for an injury that might have happened in the 1980s. Now, if you have an injury after 2013, then medical treatment is limited for a time period of 400 weeks. And that's that can be challenging for some of our injured workers who, of course, have injuries and symptoms that are ongoing. Now, we do have what's called a catastrophic designation, and those are that's a status an injured worker can apply for here in Georgia, which may potentially enable them to have lifetime medical treatment depending on the severity of their injury. And then last is when you have, again, if the injury occurs after 2013, if there is an injury that involves some kind of shoulder replacement or a knee replacement or a prosthetic or a device that will require, repair or maintenance, then they are entitled, that injured worker is entitled to lifetime medical treatment. Now, in the context of settlement, we handle settlements in Georgia the same way. So you can settle a case with open medical, which means you'll just close out the income benefit piece, and then medical treatment will remain open. That tends to happen in our cases that are designated as catastrophic. The majority of the time, insurance carriers prefer to settle the case with closed medical, and they want a clean break where our injured worker goes one way and the insurance company can go their own way.
Sure. Well, we've got one last comparison topic, and this is the one that's probably going to make me cry a little bit. But if you get hurt on the job in Alabama, you're subject to state minimum and maximum of what the weekly benefits can be, and it's 2/3 of your average weekly wage. Average weekly wage not only comprises the actual compensation that you're receiving, your checks, the gross amount of your checks, but there also can be fringe benefits can be put in there and a few other factors to help kind of beef that number up a little bit. However, our laws were put into place when David was a mere boy, a young boy, 1992. Those have not changed the numbers, but yet our cost of living has exploded in the last 28 years. So Dave, what's our current state minimums and maximums? And I'm going to just be quiet now because none of this is good, what you're going to hear from the state.
So the state average weekly wage, is $920.07. So the maximum that someone can receive if they're off work and receiving temporary total disability benefits, the maximum they can receive is $920. So if you're a real high wage earner and you get injured, you're going to get punished because you're capped at 920. Our minimum TTD rate is $253, and what's been in place since 1987 is our permanent partial disability rating, or CAP, is $220 a week.
Chinny, that was not, he didn't misspeak. That's an actual number, 220. And again, each of these different topics we could talk about for an hour, not that either of us want to, but this is hopefully going to change sometime into the future. But I'm sure what you're about to tell us is that Georgia's numbers are a lot more favorable than what you've just heard. But go ahead and tell us.
Well, for the first time, Bernard, you may not cry after this one. So
No.
In Georgia, an average weekly wage is calculated the same way. It's 2/3 of what the injured worker was making before the accident, but it's from a 13-week sample before the accident. And as of November of last year, the most an injured worker can receive was recently increased from $575 to $675. So the most an injured worker can receive on a weekly basis here in Georgia, unfortunately, is really only $675 a week, which we on the claimants bar feel very strongly does not represent or even match, what you're saying is the cost of living. And so that is, our earlier discussion today, a lot of times when my clients say, I know I'm getting this weekly check, but would it be okay if I did this or if I did that? Because that $675 it's incredibly devastating to my clients, especially if they are high wage earners. Now, we also have temporary partial disability benefits. So if an injured worker is working, but they're earning less than they normally were, we do have an income benefit that can help compensate the difference. But the maximum for that as well is $450 a week. I recently looked, WILG did this study on the compensation rates across the nation. And when Georgia jumped from $575 to $675, that moved our place in the nation from the 49th lowest compensation rate to 46. So as we stand, we're pretty low on the books.
But I don't think anyone in the country can boast or cry in their spilled milk about our 220 cap. And this will have to say for another day, but scheduled member injuries, such as a finger, an arm, etc., when we do comparisons with all of the states that are contiguous to Alabama, it's not even close. It's a shame. It really is.
Jenny, if we try a case and the injured worker is not found permanently totally disabled, then they're going to be capped at $220 a week. But then you have to take away the 15% attorney fee, so that $220 actually goes down to $187 a week. Which, who lives off of $187 a week? I mean, that's lower than unemployment compensation at this point. It's obviously lower than the state minimum. So it's been in place for over 30 years.
That's a shame. I meant to add that our TTD is capped at 400 weeks, and then our TPD, the temporary partial disability, is capped at 350 weeks. But still, numbers, Georgia, Alabama, it's still not enough.
And for guys who are still watching us, welcome to Work Comp for Nerds. We live this, we do this all the time. This is our profession, and we love it. We actually do, helping injured workers get back on their feet, helping them through the most stressful times of their lives. This is what we do. It certainly is not glamorous, but it is a profession that I truly enjoy. I know David and Chinny, you echo it, my feelings with that. We may grouse and we may complain about certain aspects of our jobs, but the bottom line is we're helping people at their time of need. And that's why we do what we do. That's why we do this show each month. Hopefully people who are out there learn a little bit, or if they have injuries in our respective states, maybe they'll give us a call. But Chinny, I certainly want to thank you on behalf of me and David and the Nomberg Law Firm for spending almost an hour with us talking about all of these articles and this information.
Thank you. It's my pleasure, and I share the same sentiment. It's really hard to save the world one TTD check at a time, but it is worth it, and it's very fulfilling. And when you see what our clients go through and their families, it's truly meaningful work. And I thank you both for what you do as well for helping injured workers over there.
Well, absolutely. And Chinny, we're going to leave David with the last word. Next week is his favorite holiday, Halloween. Albeit we're in a pandemic world, but I know David, I know he has figured out how he's going to score as many of those. Is it Kit Kat? I can't remember which one that you are so fond of, but what are your plans? We need to know before we sign off in just a minute.
Well, my birthday was last week, and my youngest daughter somewhat selfishly gave me several bags of candy. So trick-or-treating is not as important this year because I got bags of, what do we get? Werther's, peanut M&Ms, candy corn, and 2 other bags. So I got a good stash right now. I'm pretty pumped about that. So I'm not going to have to beat up any little kids and take candy.
And folks, he would.
I do think that while this show is called Alabama Work Comp Today, I do think we need to change it to Work Comp Nerds. I'm in favor of that.
We may need to rebrand it. We really should. But thank you again, Chinny. This will conclude it for this month's episode. Guys, we'll be back. Let's see, November. Oh, did I write down the date? I think it's the week before Thanksgiving. It's the Thursday before Thanksgiving. We'll put a note out. We've got Wyoming attorney, a buddy of ours, Jack Edwards, is going to join us. And Jack is such an awesome dude. He's got some great stories from his time living out west. But that'll conclude us for Alabama Work Comp Today.